be seated. For argument this afternoon is ex parte Robert W. Harrell Jr. against the Attorney General of South Carolina in Ray State Grand Jury investigation. Our courtroom is quite full this afternoon. Let me ask everyone here to respect each other and their ability to see and hear these proceedings. I'm a little concerned, I might say, about those of you who are in the back. We've got fire regulations and the need to have ingress and egress, and I want you to pay attention to anything that's asked of you of our court officials that are trying to run these proceedings. One more thing, if you have a cellular phone that you have brought into these proceedings, please silence that phone immediately. If it goes off, I'll ask that the officers take that phone and escort the holder from these proceedings. Counsel, you may proceed.
Thank you, Your Honor, and may it please the court. Before I get started, I do have to apologize on behalf of the Solicitor General, Bob Cook, who unfortunately is under the weather and could not be here today. For those of y'all that know Mr. Cook, it's a rare event that he's unable to come to these proceedings. But with that, I'd like to begin by stating that the issue today is whether or not the Attorney General, who of course is the constitutional officer with the constitutional authority to prosecute crime, and the state grand jury, which is the constitutional and statutorily authorized body to investigate public corruption, need permission from the House Ethics Committee before they have jurisdiction to do their job. And we think that the Constitution, the case law, and the statutes make it very clear that they do not need that permission. But the short and quick answer is that this court has already rejected that issue twice in State v. Thrift and State v. Peek. State v. Thrift, of course, was a pre-1991 Ethics Act case. It was under the old Ethics Act, and it started out by speaking of language that we've often seen in various opinions from this court, including State v. Langford and others, that the constitutional authority to prosecute crimes is within the Attorney General and the authorized prosecutors, that they have unfettered discretion in that regard, obviously subject to some judicial oversight, but to decide whether or not an indictment is sought, decide whether or not to seek an indictment. And other branches of government cannot infringe on that.
Does it matter that the circuit court in this instance said there was no criminal activity, at least no evidence of a criminal act?
Well, Your Honor, I think that that's mistaken because for a few reasons. And I think, number one, it misapprehends the nature of a grand jury. I think everyone's been treating the impanelment of a grand jury as if it were like an indictment or even a warrant, that there needs to be some sort of probable cause or some sort of evidentiary burden that needs to be met for a grand jury to be impaneled. But a grand jury is not that. A grand jury is there to determine whether or not there is probable cause in the first place. And so under 1630, all that really needs to be identified, and Justice Hearn wrote this when she was at the Court of Appeals in State v. Adams, is that the petition alleges the things that are necessary in the statute. And that's, of course, the consent of the Attorney General and the Chief of SLED, which happened in this case, that normal prosecutorial or investigative methods are insufficient, and that happened in this case, and that that public interest would be served by impanelment, and then just to identify the general class of offenses that are being looked into.
Now, then are you suggesting then that once the investigation gets underway by the grand jury that the impaneling judge has no authority to stop it?
I'm not suggesting that at all, Your Honor. What I am saying, though, is that power to investigate is necessarily broad, and it is under the rubric of public corruption, which is not only considered includes the Ethics Act, but could include other offenses like misconduct in office. It could include perjury. It could include a number of offenses that are in 16.9. And so that authority to investigate is very broad. It's also a maximum of law, not only in this state, but in the federal arena, which is much of our state grand jury is based on how the federal government does things, that the courts are generally reluctant, and I don't mean to state that they can't, but are generally reluctant to interfere or to engage in too much oversight over what's going on in the grand jury. And the reason for that is that ultimately, if and only if an indictment issues from that grand jury, that is the appropriate time when the proceedings for the grand jury can be viewed. And if there is a defendant who comes from any indictment, that person can make whatever motions that they deem are appropriate. So the courts have generally had that reluctance. And so I think that the trial judge in this particular instance, the presiding judge of the grand jury, had way too high of a burden. But that being said, even if you do think that there needs to be some sort of initial burden met, it was clearly met in this particular case. And that's for a number of reasons.
Well,
First of all,
let me stop you
yes,
there,
ma'am.
Mr. Waters, before you go into the specifics.
Mhm.
I take it you would agree that this particular grand jury, the state grand jury, has broad authority in a limited classification of matters.
Yes, ma'am.
And the classification we're dealing with here is public corruption.
Yes, ma'am.
Do you take the position that there could never be any examination by the impaneling judge of whether or not the state grand jury was actually pursuing something within the ambit of public corruption until an indictment was rendered?
No, what I'm saying is that that it would need to be extraordinary circumstances for a pre-indictment review to occur.
So, again, to understand your argument, then, I take it you would agree, and particularly in light of what the statutes and the Constitution say about the state grand jury, that the impaneling judge does have some responsibility, even pre any ultimate action by the grand jury by way of a true bill or a no bill. The impaneling judge has some responsibility for ensuring that the statewide grand jury is not pursuing something it's not empowered to pursue.
Yes, ma'am. I could not say otherwise because of 1630G.
Exactly.
1630G
It
says
contemplates that, and it discusses the procedure that can be used to examine the parameters of the grand jury's authority.
Yes, ma'am. I would say this, though. I would interpret 1630G in light of how grand juries, again, as I was just talking about, how the judicial oversight is usually done with grand juries. And if you look at the federal cases, many of the federal cases that we cited in our pleadings below, they talk about that general reluctance of the court to engage in pre-indictment review, and it needs to be an extraordinary circumstance where serious abuses are being shown. So while I certainly concede, as I must, because the statute says what it says, that there is certainly some oversight in the way our state grand jury is constructed, I think it would have to be in extraordinary circumstances. And usually the way that would arise, and the way most pre-indictment grand jury matters arise, is when a subpoena is issued and someone moves to quash that subpoena. And based on that, they say, why am I being subpoenaed? Nothing I could possibly offer could have anything to do with what the grand jury could permissibly look at. And that is usually how that would arise.
Right. And in the peculiar circumstance of this state grand jury, it really is kind of different from normal grand jury decisions about the panoply of authority, county by county, for grand juries to examine things, as it is the federal, where there's a very clear arrangement of statutes under which federal courts pursue matters. This is a very circumscribed, specialized grand jury, this statewide grand jury.
Yes, ma'am, it is. It's a
And
major statute.
what,
Yes.
I'm leading to this question.
Yes, ma'am.
Just as you agree that under extraordinary circumstances, the impaneling judge may be required by statute and his responsibility or hers to examine pre-indictment the propriety of what's being explored by the grand jury, whether it's within its power to explore. Would it also be within the authority of the impaneling judge to explore whether there are any conflicts of interest on the part of the Attorney General with respect to participation in the activities of the grand jury?
I would answer it like this. Two things. Certainly, the presiding judge under our state grand jury, which is a little different from the federal grand jury in that it is a creature of statute. However, it is generally based on the operations of the federal grand jury, and I think that their case law is instructive. And what they have said is that you do not want to burden the grand jury with many trials after many trials prior to any indictment, that would then impede the pursuit of justice, that would impede the search for truth.
Well,
And
this
that-
wouldn't be something the grand jury would consider. This would be something what I'm asking is whether the impaneling judge
Right.
of the grand jury can pre-indictment consider the propriety of the participation of any prosecuting officer who comes before the state grand jury with
Right.
respect to the normal rules of the road of conflict of interest, disqualification, things that are considered all the time in normal criminal proceedings.
Yes, and that obviously goes to what was initially before the court raised.
Right, and that hadn't been
jurisdiction.
decided yet.
Right.
We still haven't had a hearing on that matter.
Right, and our position before the court was, obviously, the statute does speak of the presiding judge making the final decision if there is a conflict. Statute again says what it says. However, our position before the court, and the pleadings are in the record, the initial pleadings before we got to the jurisdictional issue, again, was based on the federal case law, based on the general reluctance of the court to engage in oversight of the grand jury pre-indictment unless there are extraordinary circumstances or serious abuses.
So we do agree then that in terms of the authority of the court,
Right.
you're here arguing that the court, the circuit court, the impaneling judge had the authority to impanel this jury.
Right.
Its jurisdiction is not impacted by the ethics rules of the road in terms of the expiration within an ethics committee or the ethics commission of civil ethics matters. You say the circuit court still has jurisdiction. And I understand you also then to be saying that once an impaneling judge has the responsibility of supervising the work of the grand jury, that impaneling judge, for extraordinary reasons, has the authority to look into the parameters of the grand jury's investigation as well as the propriety of the lawyers for the state who come before that grand jury to present, correct?
I could not say otherwise because that's what the statute says. I would, though, say this, and I want to stress this, is that oversight, again, and I think it's Bank of Nova Scotia, but these are cases that were cited in our pleadings to the disqualification motion, make it very clear that the court should be very reluctant and careful to do that because otherwise the grand jury would be unduly burdened and the search for truth would be thwarted with the delay of motions after motions after motions and mini trial after mini trial before the grand jury could get to its work. And so the federal courts have said while that may be necessary, it would have to be an extremely high showing, an extremely unusual and extraordinary circumstances showing serious abuses before the courts should engage in that. And I think that that's an appropriate rule for the reasons that the federal courts have expressed because otherwise you would impede the workings of the grand jury.
Use that as a segue to the issue sua sponte raised by the trial court, that it lacked jurisdiction because of the pending ethics complaint.
Sure. I think that there's a number of responses to that. And again, I was starting with Thrift and Peak. And Thrift and Peak very clearly have already rejected this, and they have said that the mandatory referral provision, or the referral provision is not a mandatory prerequisite to prosecution. Because to construe it like that would make the statute unconstitutional. And of course, it's a general rule that this court will not construe a statute in a manner that is unconstitutional if it can be construed as constitutional.
So the two inquiries could exist in parallel.
And absolutely, civil, and that's exactly what Peake said. You had that DHEC statute, and Peake clearly said the injunction part is DHEC, the criminal part is the AG, and that exists all through the law. I do a lot of...
Reconcile that with Rainey.
Excuse me?
Reconcile that position with Rainey, even if they're not opposite.
Well, Rainey was completely different, and I believe your concurrence...
It was correct, wasn't it?
It was very correct. I like it very much.
I thought so
I'm a big
too.
fan of both of y'all on my particular concurrence, but obviously Rainey was...
Well, and just there's nothing in the majority of Rainey that disputes that, is there?
Absolutely, and I think that-
Often concurring opinions flesh out other things that aren't covered in the majority opinion, but there's nothing in the majority opinion that disputes the further analysis that was contained in the concurrence, is there?
No, and I completely agree, and I think that the reason for that is because the majority held that, that there was no jurisdiction in the circuit court because this was not the 50-day exception, and so therefore the majority needed to go no further with its analysis.
Well,
The
can I get
concurrence-
to this? The reason why I took you there, Mr. Waters, is this. Rainey uses that exclusivity language.
It does.
And Mr. Harrell's camp makes a lot about that.
Absolutely.
Does that really mean anything?
No, sir, because absolutely, the House Ethics Committee has an exclusive authority for the civil regulation of the Ethics Act. And in fact, Rainey, the majority opinion, says it much. It says the legislature has established a comprehensive scheme for regulating. Regulating is different from criminal penalties, and that distinction exists throughout the law, and in fact, in most cases where there's an extensive regulatory body. And I was about to say securities law. That's an example of one. We have the Securities Commissioner. I do a lot of white-collar security stuff. We're behind locked doors on the other side. The same conduct can be, at the same time, subject to both civil penalties as well as to criminal penalties. The DOR, Department of Revenue, the IRS, has a whole a whole doctrine about when it goes from civil to criminal. So I think that's what the trial judge failed to perceive was just because something can be civil, and there's no doubt that Rainey is completely correct that as far as the civil regulatory authority goes, that's in the House Ethics Committee. That has absolutely nothing to do with the ability of the Attorney General at his discretion, which is constitutionally protected, to seek criminal enforcement of the Ethics Act, which every violation of the Ethics Act can be a criminal offense under 1520. Which
And you have the authority to decide who you're going to prosecute.
I'm sorry?
You have the authority to decide who you're going to prosecute, whether they commit the same offense or not.
That is true, subject to, there is obviously concepts of selective prosecution and vindictive
Well,
prosecution.
and there's
that sort of
also
thing.
thrift itself. In the thrift case, the Attorney General had already pursued prosecutions of the thrifts, in fact, made a pretty political decision to pursue those in Horry and not in Greenville.
Right.
This was before the statewide grand jury came into existence.
Right.
And then made a plea bargain, a pretty favorable plea bargain to the thrifts that allowed them to get out from under debarment by not pursuing bribery, although clearly the information was that bribery had taken place. And then as soon as the state grand jury came into existence, the Attorney General tried to re-indict the thrifts.
Correct.
And this court held that the state grand jury's activity could be examined in light of our constitutional regulations
Right.
to decide whether or not that prosecution could be pursued at all.
And I conceded at the very beginning that while the Attorney General has that constitutional unfettered discretion, it is subject to judicial oversight and for selective prosecution, for vindictive prosecution, prosecution based on impermissible considerations. And in this particular case, the prosecutors obviously have an obligation to ensure that if they engage in a plea bargain, that the defendant gets the benefit of that bargain. Those are some examples of things that do circumscribe generally the prosecutorial discretion, but none of those whatsoever are present in this particular case. None of that exists here. And again, we're just talking about an investigation, a grand jury investigation, which, again, is the beginning. It's not the end. And I think that that's where we've kind of gone off the rails a little bit, because we're at the beginning of this process, not the end. And I think the trial judge treated it as if it needed to be justified as if it were an indictment or it was a warrant. And that's just not the case. But even if you did, and before I move on, going back to distinguishing Rainey, the other thing, Rainey had the exclusivity language, which again, I don't believe it applies here because Rainey was a civil matter filed by a person, a private citizen, in common pleas court seeking a declaratory judgment, whereas here we have the Attorney General, who's constitutionally authorized, seeking a state grand jury investigation in matters of public corruption, which again is all constitutionally and statutorily authorized. But Rainey also talked about separation of powers, and I think we pretty clearly point out that separation of powers, Article 3, Sections 11 and 12, which generally give the legislature the power to judge the qualifications of its own members, does not in any way preclude the executive from indicting and seeking conviction of a legislator for criminal conduct. Now, what the legislature does with that is completely up to them. We could convict somebody of murder, and if they want to pass rules that the murderer can sit in the legislature, that's fine. There's not a thing we can do about that. as the executive. However, nothing about the separation of powers referred to in Rainey affects the ability of the Attorney General to pursue.
Procedurally, what did happen with the House Ethics Committee?
With, in this particular case?
Is anything pending before the House Ethics Committee?
Not of which I'm aware.
Did the House Ethics Committee ever refer this matter to SLED or the AG or to anybody that you know about?
I don't want to go outside the record. I do believe, and I do believe there was a discussion of this in the record, that the citizen who brought this complaint did go to the House Ethics Chairman, who said, if you believe that you have criminal violations, and by all means, I mean, there's nothing I can do to stop you from going.
Yes, that's in the record. And
Yes.
what I'm curious about was anything then ever done by the House Ethics Committee in that regard?
Not that I'm aware of, no, ma'am.
Was anything formally ever filed with the House Ethics Committee?
No, ma'am.
Does it matter?
I do not believe so. Because again, the regulatory scheme that is at issue under 540, by the plain language of the act, has nothing to do with 1520, which criminalizes all of these violations. And as all those federal court opinions that
So are all ethical violations criminal?
they can be.
Can be or are?
They can be. It says that the violation of this act is a misdemeanor. However.
And who makes that determination, Mr. Waters?
Well, the way that in practice we separate what is appropriately civil and what is appropriately criminal is mental state. There needs to be a criminal mental state. And obviously a prosecutor would initially make that determination that the evidence was sufficient to go forward based on that distinguishing factor that there was a sufficient criminal mental state. Then obviously it would go to a trial, and ultimately a judge would give whatever charges he or she felt were appropriate, and then the jury would make that determination as to whether or not the individual was guilty. But that's the determining factor between what is appropriately civil and what is appropriately criminal, and that's that mental state. There's a lot to cover. I know we would obviously rely on our brief. I'm out of time. I'm happy to answer any more questions. If not, I'll.
You'll have some time to reply, Mr.
Yes, ma'am. Thank you.
Mr. Staff?
May it please the court. Bobby Stepp and Mr. Daniel and Mr. Howe and I are here today to represent the respondent, Robert W. Harrell, Jr. And I appreciate the opportunity to come and address these issues with this court. I think the issue in this case is whether the Attorney General, under the guise of a criminal investigation, can usurp the exclusive jurisdiction, the exclusive statutory jurisdiction of the House Ethics Committee over an ethics complaint made by a private citizen. And by doing so, upend the extensive and unambiguous statutory scheme that this court reviewed and approved in the Rainey decision. So a decision in this case that would permit the Attorney General to proceed with this grand jury investigation under the guise of public corruption would be contrary to.
You point out a striking similarity between this case and the Rainey case, both at the behest of private citizens. What is the difference here? Rainey sought a declaratory judgment action that perceived ethics violations were criminal in nature. What's the difference here?
I don't think there's any difference, Justice Placonis. Both of these cases proceed from a private citizen's complaint. In the Rainey case, it was obviously Mr. Rainey who went to the Court of Common Pleas directly and asked the Court of Common Pleas to issue a declaratory judgment that Governor Haley, in her capacity as a House member, had violated the Ethics Committee. And the court declined to act, and this court concluded that there's an extensive and unambiguous statutory scheme that contemplates that investigations of violations of the Ethics Act are within the exclusive purview of the legislative branch, to the exclusion of the courts. And that was the language of the majority opinion in Rainey. Now, in this case, we've got a private citizen, Ashley Landis.
Mr. Waters alleges that only applies to those matters that are considered civil.
Well, Your Honor, I'd like to address that because I think under the Attorney General's position in this case, the distinction doesn't exist. In the Landis complaint alleged what I would certainly consider to be civil violations of the Ethics Act. And she even prepared that complaint on the form prescribed for use before the House Ethics Committee. But instead of taking it to the House Ethics Committee, she takes it to the Attorney General. The Attorney General then makes the unilateral decision that somehow or another there's a conflict of interest in the Ethics Committee, and he appropriates this investigation to himself. Well, let's stop right there. What is he investigating? Alleged violations of the Ethics Act by a private citizen, the very thing.
What would
this court-
happen if the individual did not go to the House Ethics Committee, but went to a law enforcement officer, or the Attorney General, and says, I want to file a complaint for criminal violation of the Ethics Act?
Well, I
What's the
think,
result?
well, I think
So we're
obviously.
making a distinction because of which they enter door A or door B.
Well, I don't know how to make that distinction, and that's one of our problems, but any such complaint, the complaint in this case, when it was directed to the Attorney General, should have been referred to the House Ethics Committee. I mean, that's what the Attorney General himself, on numerous occasions, and we put this in our book.
Assume that formulation is correct. At what point in the process, or what triggers the ability of the Attorney General to act?
Well, Your Honor, if you take their position in this case, and Justice Beatty just asked the question, are all violations of the Ethics Act criminal? And I didn't hear a distinct answer to that. But
Well, the
their
answer was if we wanted to be.
Well, that's the problem. Their position is that, yes, they all are criminal violations, and therefore,
My
any
question
com-
stands, when in the process may the Attorney General act?
the Attorney General may act if he's got evidence of violations of law other than a violation of the Ethics Act, or after referral by the Ethics Committee.
What if the Ethics Committee never makes a referral?
Well, then he can act, because they're statutorily required to do it. And if the Ethics Committee doesn't do what it's supposed to do, then that would be a different circumstance. But that's not what we've got here. What we've got here is this
Then you're suggesting then it should first go to the Legislative Ethics Committee, the House Ethics Committee in this case, and then go to the AGs?
Well, I think under his position, and this is all I can deal with, because I don't really know how to distinguish. I'll be honest with you. I don't know how to distinguish if there is a duality of a violation, if it's sometimes civil, sometimes criminal. I don't find in any of the decisions of this court or in the statute a guide that tells me what's what. So that's part of the problem. But under the AG's position, every complaint could be investigated by the Attorney General as a criminal violation. And every complaint, therefore, the Attorney General could involve
Isn't
himself.
that what the law says? I mean, tell me what in the law that says that's not the case.
What's in the law that says that's not the case is the statute in section 540 and this court's decision in Rainey. Both say investigations of violations of the Ethics Act are within the exclusive purview of the legislature. If the Attorney General can criminalize any violation and start an investigation, at best, that creates concurrent jurisdiction in the Ethics Committee, not the exclusive jurisdiction that this court found in Rainey, because the AG could always be involved. In this case, he could involve himself to the exclusion of the committee. And the whole thing gets turned upside down, because in the statutory scheme, the committee would investigate, make findings of fact, and if it determines there's been a criminal violation, refer it to the AG.
Let me ask you this, Mr. Stepp. I thought I heard you to remark, excuse my voice, that the Attorney General arrogated to himself the responsibility for determining that there was a conflict of interest. Did I hear you say that?
Yes, or something to that
Okay.
effect.
Yeah, as I understand it, the Attorney General, rather than beginning his own investigation or submission to the state grand jury, sent this to the state law enforcement division for investigation, did he not?
He did, but he candidly admitted in an affidavit filed in the lower court that he did so without any additional information. He simply handed over the private citizen's complaint to SLED. He should have handed it over to the Ethics Commission. There's nothing in the statute that says that the Attorney General can decide which cases the committee has exclusive jurisdiction over. He's not permitted to amend the statute or to make a unilateral declaration of a conflict of interest and thereby deprive the committee of the jurisdiction afforded to it by
But
statute.
what about the constitutional provision that gives them the authority to prosecute all criminal matters?
Well, if it is a criminal matter, if there's evidence of a crime other than a violation of the Ethics Act, then obviously he can proceed. We've never taken any position to the contrary of that. But we read Thrift, of course, to say that violations of the Ethics Act are civil.
Well, here's another thing that Thrift says. Because the old Ethics Act had a very specific referral procedure, as you may recall. And then the new Ethics Act came along and did not have that provision in it. And I'm sure you remember the Thrift case because your partner,
My
Ms.
partners were
Gray,
involved.
was very involved.
Mr. Howell was involved as well.
Exactly. And so we were trying to sort out how all that worked. And what we said in Thrift was the absence of a complaint to the Ethics Commission will never operate as a limitation upon the state's independent right to initiate a criminal prosecution. Now, this was the State Ethics Commission, not the House or Senate Ethics Commission. And there may be some distinction there that you're going to make. But what this this passage from State versus Thrift discusses is whether or not these things can proceed in parallel. What is your position about whether they can proceed, that is a House ethics investigation and a state grand jury investigation could proceed in parallel?
Well, I don't think they can proceed in parallel if what the state grand jury is investigating is simply an alleged violation of the Ethics Act. And I'll tell you why, if I may.
Certainly. And when you're answering the question about in parallel, help me with this. The House Ethics Commission apparently does not have any complaint in front of it. The House Ethics Commission, what our record says, at least its chair, told the complainant, if you've got a criminal complaint, you should go see the Attorney General. It's our understanding that a SLED report was done, and then the matter was submitted to the grand jury. I find it curious that we know all that, because frankly, I've never heard of having press conferences to announce that you're going to submit something to a grand jury, ever. I've never heard of that except in this case. But be that as it may, we now know from this record that it wasn't simply a civil complaint by a citizen, but rather a report by the State Law Enforcement Division that was submitted to the grand jury, and as a result, or submitted to the impaneling judge. And as a result of that, the impaneling judge impaneled a state grand jury. Does that make a difference to the in parallel discussion we're having now?
Let me answer the second question first, since it's on my mind, and I might forget it if I put it aside. The answer to that is no, it does not make a difference. That SLED report was not part of the record in this case, and it's not part of the record before this court. The lower court invited the Attorney General on more than one occasion to make a showing, we think pursuant to 1630G, that the grand jury was operating within its constitutionally limited jurisdiction and that there was evidence of public corruption. I mean, the other big distinction here, which if I may digress just a moment, it's not enough in our case for there to be evidence of some criminal activity. So even if you can say that every violation of the Ethics Act is, or might be, a crime, that's not public corruption. I mean, it's inconceivable that the General Assembly intended the state grand jury, when you read its enabling legislation, to be convened to investigate a misdemeanor punishable by $500, or that somebody that doesn't keep a receipt for campaign expenditure is going to get prosecuted by the Attorney General for public corruption. I mean, that couldn't have been within the contemplation of the General Assembly when it authorized the grand jury to act. But the SLED report is not part of this record. Now, there are some suggestions in the record that Judge Manning may have seen the SLED report. Now, as I think y'all probably know, you don't see me up here on criminal cases, so I'm a little bit out of my water. But I read State versus Adams, Justice Hearn, your decision in that case, which talked about what that impaneling process is. And with all due respect, it seems to me to be a check the box, that there's a petition filed that says, yes, we're investigating something that's within the statute, and yes, I promise that that's what we're gonna do, and that's about it. So the fact that the grand jury was impaneled, even in the absence of any evidence, is not itself evidence of any criminal activity. Then in this record, when the court asked for evidence, it didn't get any evidence. So in our case, whatever may be the hypothetical situation of some dual violation sometime in the future or somewhere else, we don't have any evidence in this case that the grand jury was acting with respect to information about public corruption. And so therefore,
And in your view, in order for us to consider that, that is to say, whether there's evidence of public corruption sufficient for the state grand jury to have been impaneled, that evidence would have had to have been presented in the hearing that was conducted in front of Judge Manning.
that's what 1630G
It could not
requires.
be considered for the first time up here.
That's correct, not the first time on appeal and not post-indictment.
How does that work when a grand jury's proceedings are traditionally conducted in secret, and that you don't reveal what is submitted to the grand jury outside of the confines of the presentation of the grand jury?
Well, it's an unusual process, but certainly the Attorney General could have proffered the information for in-camera review, for example. I'm not saying there wouldn't have been discussion about that, but there are ways to put information before the court that does not violate the secrecy provisions. The other thing is that the secrecy provisions, as I read them, really only apply to the actual evidence presented to the grand jury, and that there are
Well, the grand
ways
jury
to...
witness can testify to whatever he or she said in front of the grand jury. I mean, everybody knows that.
That's right. So I think there might have been a way, short of violating those secrecy statutes, to make that showing, but at the minimum, there should have been a proffer of something. And then if the court wouldn't take it in camera, then that would be a whole nother set of issues. But we don't even have the proffer in this case.
So as I understand the argument you're making, it is that all that was ever in front of Judge Manning was allegations that were purely civil in nature.
Correct. Correct. I mean, the only reference, the Landis complaint is in the record. You can take a look at it for yourselves. I'm sure you have. There is reference in there. The only thing in there that even smacks of criminality is her concern.
The word criminal.
Well, the word criminal's in there, that's right. But, Ms. Landis is not a lawyer. Her theory is that if you commit enough civil violations of the Ethics Act, apparently you might be guilty of a crime. Well, that's an interesting theory, but it's not the law.
Well, I'm sorry, go ahead, Mr.
I'm done, thank you.
Even assuming that these allegations were allegations of crime, must there have been some evidence presented to Judge Manning when he requested it of this criminal activity?
Yes.
To proceed further?
Yes, absolutely. Judge Manning was completely within his authority under 1630G to hold the Attorney General to account for the activities of the grand jury at the risk of dismissing the grand jury, which is exactly what the statute says. And when confronted with that, that's not going to happen in every case. Obviously, this would be a very rare circumstance, but it happened in this case. And the Attorney General was under an obligation to present that evidence. He was invited to do it. He didn't do it, and Judge Manning, therefore, was completely justified in concluding that in the absence of any showing that the grand jury was acting within its constitutionally limited jurisdiction, it should be dismissed, and this proceeding is null and void.
But Mr. Stepp, there is this. This isn't strictly, this isn't purely a check-the-box situation as you have described in State versus Adams. Our record does contain, and I forget whether it's press releases or just what it is. Again, that is not a practice that I have been familiar with prior to this thing, that lawyers conduct their business this way. But in this case, in our record, there apparently is some sort of statement, public statement, by the Attorney General's office that it received the SLED report, and that it then sent the SLED report to the state grand jury. And then there is information we have now, again, that normally you wouldn't have. We normally don't know that state that a state grand jury is impaneled. But we know from this record that a state grand jury was impaneled at some point after the SLED report was sent, as the Attorney General states he did, to them. So the Judge Manning would have had in front of him information that's not simply what we have, which is the civil complaint of a citizen. He would have had some other information about whatever the investigation would have shown about criminal activity, would he not?
Well, he might have, but I've got two responses to that. Number one, that press release is not evidence, and I
Well,
don't-
all we can do is go on the basis of what you all prepared for us in this record. And it
Your Honor,
contains, the whole behavior here has been very strange to me, but that's one of the things that's in this record.
And what's not in this record is any evidence of conduct that amounts to public corruption. We got a press release.
Well,
We don't
along
have
that
any
line, Mrs. Steph, do you view the function of the grand jury to investigate allegations of crime, or do you view the grand jury as being someone who to review allegations, well, evidence of crime, to determine whether or not an indictment is warranted?
Well, I'm not sure I understand the distinction, but certainly they would investigate.
Well, one would require the AG to come forward and present this evidence, as apparently Judge Manning thought they should have, at least to him. On the other hand, to just sit and wait,
Well,
or investigate themselves, if you will.
Well, I think under 1630G, the Attorney General was obliged to account to the court by means of evidence, by making a record, not by issuing a press release, but
So
by
it's not
making
an
a record.
investigative body, the grand jury.
Yes, sir. I think it is. But the 1630G says that if the investigative activities of the grand jury are without its jurisdiction, the court can discharge it. And so the only way that that's enforceable is to make the prosecutor operating the grand jury accountable to the court by means of evidence and not by simply means of allegations. I think it has to move beyond the allegation stage at that point, and you gotta have some evidence. And the Attorney General was given that opportunity in this case, and he absolutely failed to do it. And so he left Judge Manning really with no choice but to say, I don't have any basis to conclude that this grand jury is operating within its constitutionally limited jurisdiction, and I'm gonna dismiss it. And that's what happened. So I think in this case, and let me address your other point, Your Honor, if I may.
Yes, you may.
I agree with you. This case is unprecedented in terms of how it has been handled and the publicity associated with it. And I just want to say that the press releases, the public statements, the fact that the Attorney General consistently has publicly commented about allegations of criminal activity involving Mr. Harrell has severely prejudiced him. It has clouded the atmosphere of all of this case to where everybody walking around reading the newspaper thinks he's, if not guilty, at least suspected of criminal activity. When we think all of this emanates simply from a civil complaint. And we think the grand jury has been improperly impaneled, and that provides the basis for these statements to be made. So the two things, the improper impanelment of the grand jury, the failure of the Attorney General to refer this case to the Ethics Committee, which this court has said where it belongs, has severely prejudiced Mr. Harrell. And there's got to be some remedy for that. So even if, and I'm not conceding this point.
Tell me what that remedy is, because that's what I'm interested in. What if we were to agree with you that Judge Manning's order should be sustained, okay, affirmed? Where do we go from there?
Well,
If anywhere.
that is the remedy, number
That's
one.
it.
I think you should affirm the order. And then if the Attorney General can, by means of other information, if he can proceed with some criminal investigation, he can do that, but he's gonna have to.
The order stops any investigation whatsoever by any other body.
Well, I'm not willing to go that far, but I don't think this record justifies any further investigation. So there would have to be something new and different. I would concede
Well,
that.
how do you get there? You can't go to a grand jury, you can't go to the county
Well, he can investigate. I mean, you know, maybe somebody else comes to him.
Well, surely, even if the order of Judge Manning were to be sustained, surely, this would not prevent the Attorney General from making another petition for impanelment.
That's right.
I mean, you wouldn't go that far with it.
No, Your Honor, that's the distinction.
I think that's what perhaps is being asked, because the language of the order is quite broad and
I'm
seems to
sorry.
infer that there could be no investigation.
I misunderstood. Of course, obviously, my position to be that there ought to be no investigation, but I don't think I can, you know, really make that argument credibly, and so I'm not gonna do it. But he'd have to start over, because we don't think if he had to start over, he can get it. We don't think he can properly invoke the jurisdiction of the grand jury. So, we think this proceeding ought to be stopped in its track. Judge Manning's order ought to be affirmed. This grand jury should be dissolved, nunc pro tunc, and all of its activities declared null and void. And then, if the Attorney General can justify further investigative activity, if he can justify convening the grand jury on the basis of evidence of public corruption, then we'll deal with that when the time comes.
Mr. Stepp, what if we don't accept your argument? What if we reverse Judge Manning? Where does that leave you?
Well,
There's never been a ruling on the motion that was actually before the court.
If you reverse Judge Manning, it needs to be sent back for a decision, first and foremost, on the motion to disqualify. And I would hope that we could stay the investigation until that were determined. But that would be the very first issue that would have to be decided upon remand. Your Honor, we think this case is just like Rainey. We think jurisdiction to investigate allegations of violations of the Ethics Act, particularly allegations made by private citizens, belong within the exclusive purview of the legislature. And we think that the Attorney General's actions in appropriating this investigation to himself and convening the grand jury were unlawful and improper. And we would ask you to affirm Judge Manning's order in its entirety.
Thank you, Mr.
Thank you.
Stepp. Mr. Waters, in reply?
Thank you, Your Honor. I think Justice Beatty was hitting on precisely the point, and I think, again, we've gotten off the rails with this idea that there has to be an evidentiary showing for a grand jury, which again is the beginning, not the end. And any Ethics Act violation.
If that be the case, Mr. Waters, how does the judge who impaneled the grand jury adhere to his obligation under G, I believe it is? Is it G or F?
That's my question. What is he supposed to know when he impanels a grand jury?
Well, and that's what I want to get to, because the judge put in his order, well, despite repeated requests, I didn't receive any information, and they have picked up on that, but I have to disagree with that. This same judge got the petition, got the supporting
Well,
affidavit.
stop right there for a moment, Mr. Waters. I think what everybody on the court is asking you, and I'll join them, is start at the beginning and explain to us what, in your view, must be shown by the Attorney General to the impaneling judge in the first instance.
Right.
To justify impaneling a grand jury. What must the judge be shown, and what determination must the judge make at that time?
The statute has essentially four things. The first thing is the chief of SLED and the AG agree that it should be impaneled, and that normal prosecutorial and investigative techniques are insufficient. Number two, the petition has to show the crimes to be inquired in. It doesn't create some sort of evidentiary bar that we have probable cause that these crimes are being committed. All it says is that it has to identify the crimes that have been that are to be inquired in. And then number three, the petition has to specify that the public interest is served by the impanelment of this grand jury. So again,
Let's assume then that those requirements are met.
Right.
How do you keep it? How does the impaneling judge adhere and perform the obligations under 1630G?
Right.
That is to make certain you do what you're supposed to do.
Right. Well, again, number one, I think it would, as I argued earlier, based on all the federal case law, it would have to be extraordinary circumstances.
I'm not concerned with the federal
All right,
law.
but number two.
It doesn't mean nothing in this.
Number
court.
two, our enterprises does speak of an in-camera review, but the judge, this is the very judge who considered that petition and
But if what the
supporting
judge
affidavit.
was asking you at that time was, as I understood the transcript, to simply list for him the criminal matters that were being inquired into. Not the simply civil ethics matters, but the matters that were criminal in nature.
Your Honor, on page 215 of the record, line 19, okay? And this is why I think this is unfair to say, well, the AG, I mean, we can't talk about this publicly. This was a public hearing. These are secret documents.
Well, I mean, the
The AG
Attorney General
says-
has talked about some of these matters publicly, Mr. Waters.
More than once.
The AG says, Judge, you
What
have-
page are you on?
I'm sorry, page 215, starting at line 19. Judge, you have seen the petition. You have seen the information that we brought to you, and that is, and the court cuts him off. And this is talking about the petition, the supporting affidavit, and says, we don't know, you need to go too far. I know what you're saying. This is the very judge who had seen that information that we brought him. So of course we thought, okay, he knows what we're talking about. That's the information that we brought. And that was the information that was after a 10-month SLED investigation that led to the need for more inquiry. Okay, and again, this is the beginning, not the end. And all ethics violations can be a crime, and so certainly is within prerogative of the grand jury, if there are evidence of ethics violations, to look at those and determine whether or not there is sufficient evidence as well as criminal intent that they rise to the level of an indicted crime. And if you look at, he keeps talking about, well, ethics is different from the jurisdiction of the state grand jury, but the public corruption grant of jurisdiction to the state grand jury, and we detailed the history very much, was in sync with the development of the 1991 Ethics Act. Those two went hand in hand, and there was an attempt to push it back, and the voters rejected an attempt to take that public corruption jurisdiction away from the grand jury, and it was put in there around the same time that the 91 Ethics Act was passed, and it was all, of course, in the historical context of lost trust, in which, we all know what that was. That was a huge corruption scandal in the legislature. So if you look at that in historical context, their position makes no sense with the historical record. And again, it also makes no sense with just the simple plain language of the statute. 540 and 1520 are separate and apart, and neither one refers to the other. And the federal courts, in addressing FECA, and if you look, and I detailed that in the brief as well, that the FECA was clearly the inspiration for much of the 91 Act, that the federal courts have been uniform in saying a provision like 540, which says the ethics commission can, or the ethics committees can refer things to the attorney general, that only deals with what they can do and when they can do it. It has no bearing whatsoever on when the Department of Justice in those federal cases or the attorney general here.
Well, we don't need to go there. The Thrift case says the absence of a complaint to the Ethics Commission will never operate as a limitation on the state's independent right to initiate a criminal prosecution. Now, that was the Ethics Commission, but your position is that the absence of a complaint to the House Ethics Commission or the Senate Ethics Commission or the State Ethics Commission does not impede or limit the state's independent right to initiate a criminal prosecution. Isn't that correct?
That's correct. There's no different. There are some differences between what the Ethics Commission statutes from 300 on up say and what the House and Senate committees say. But that does not affect the fact that there were referral provisions in each, okay? And neither one of them expressly says, oh, by the way, unless we say you can do it, Mr. Attorney General, you can't. And they easily could have said that, and that's what the federal cases say as well, that if you're going to do something as unprecedented and extraordinary as infringe upon the constitutional discretion of a prosecutor to handle prosecution, we've got to have a clear and unambiguous expression of the legislative will, and that's simply not present in this statute.
Mr. Waters, I hate to keep harping on this one.
Yes, sir.
But I'm way past that point.
Yes, sir.
I'm at that point where Judge Manning says there is no evidence of criminal, you're not presenting any evidence of a crime.
Right.
Therefore, you're not pursuing the purpose of the impanelment of this grand jury.
Right.
Now, that's what I want to see. Now, this investigation had gone on for quite a while. SLED you had more than the allegations by Ms. Landis. You had a SLED investigation. You had turned it over to them. Didn't you have something that you could have given the impaneling judge to keep your investigation before this grand jury going?
Your Honor, I think again, and
I read that, but that's, I also read a little bit after that where Mr. Wilson said, well, in effect, we don't know. We got to wait to see if we find anything or not.
Well, I'm not sure that Of which,
Well, what he says was, which may or may not yield anything. We're waiting on the grand jury to conduct this work.
again, because the grand jury is the beginning, but again, he had seen that petition, he had seen that supporting affidavit.
Those are just allegations. That can get you the grand jury. What keeps the grand jury in panel is what I'm asking you.
Well, again, then I would have to disagree on the interpretation of 1630G, and if I could, I'll explain to you what I mean. I said earlier that the federal courts have been very.
And I'm not impressed by that.
Yes, sir. All right, but 1630G says that if there is evidence that is presented, and I don't have this statute in front of me, but I can get it, but it essentially says that, of course, indulgence, 1 minute.
I can read it to you if you like.
I've got it right here. If at any time during the original term, the presiding judge determines the grand jury is not conducting investigative activity within its jurisdiction or proper investigative activity, the judge may limit the investigation or he may discharge the state grand jury. What I think that would.
As far as I'm concerned, that's what keeps Judge Manning's order going, if in fact that's true.
Right, and what I would say is I believe that statute does not require sort of a periodic showing that to the judge. I think there would need to
But
be
even if he
some-
requested.
If he requested, and I think again that he was aware of that petition. He was the one who signed the order after receiving that petition. But let's just take that out of there. Again, if we look at the Landis complaint, and we've detailed through there the repeated allegations of criminality, we've established that Ethics Act violations can be criminal, and it is necessary for the grand jury to look at that information to determine whether or not it rises to a level of criminality.
Is there any activity that constitutes a violation of the Ethics Act that would be looked at by the Ethics Commission or the House or Senate Ethics Committee that's purely civil in nature, in your view, and not the proper purview of the state grand jury?
The 1520 does not expressly have a mental state. However,
Help me with that.
yeah, however, and actually it's interesting, if you look at the legislative history, there was willful in there and it was taken out. However, this court has on occasion, and I think appropriately, inferred a mental state into a penal statute where that is appropriate. And there,
Well, if it's a penal statute, there has to be some sort of mens rea in order for it to be penal, doesn't it?
Absolutely, and in any sort of case, the judge is going to charge a general criminal intent charge. So, I believe that there is a mental state in that statute, and that is how we treat it. That is what separates the wheat from the chaff. And so that is the distinction between, it's not that hard, it's the distinction between somebody who messes up accidentally or has some errors or something short of knowledge of wrongdoing or intentional wrongdoing, knowledge of the rules, breaking the rules, something along those lines that crosses the line from a mere mistake to somebody knowingly taking advantage of the rules to their personal benefit. That is how we draw the line, and I think that's implicit in there. Thank you, Your Honor. I'm seeing I'm out of time. Your Honor, if I could, just one last point.
You may.
I know I'm going to draw fire for this, but I do need to bring this up. I know Your Honor has raised concerns, and I hear those concerns about the press release that was entered in this case as
I
never
don't
having
think you
occurred
need to
before.
argue that, Mr. Waters, and I understand that your boss may want to have some apologia pro sua vitae put in by you, but you don't need to go there.
Thank you very much, Your Honor.
Thank you. Court will be in recess.